All right, hey there, everybody. Welcome to another episode of Logically Speaking, our legal talk show on everything legal, anything Florida law related, and any type of, running the business of law, legal tips, any and all things legal, and as it relates to Florida law. Tonight's topic are Miranda warnings, anything and all things Miranda warnings. What are they? When do they apply? And what happens if Miranda warnings aren't read to you? So most people are familiar with those court TV shows or movies and have heard the Miranda warnings given in TV shows. Miranda warnings are your right to remain silent, the right to have an attorney appointed, and so those are the different types of Miranda warnings that we have and that law enforcement reads to persons who are being arrested for crimes. So let's talk about specifically what each part of the Miranda warning is, and then we'll talk about when do they apply and then what happens if they're not read. So what the Miranda warnings are, that one of the first parts of it is you have the right to remain silent. Anything you say can and will be used against you in a court of law. Importantly, um, the important part of that is that one, you have a right to remain silent. Two, if you choose not to remain silent, anything and everything you say can and importantly will be used against you when you go to court. So when you are being arrested and law enforcement questions you, you absolutely have the right to invoke your right to remain silent and to not speak to law enforcement. You are under no obligation to speak to law enforcement when you are arrested for a crime. And law enforcement, when they are investigating a crime, sometimes they use the tactics and they come across very nice and they come across like they're your friend and that they're there to help you. But if you are arrested for a crime, you are the suspect of a crime. Law enforcement is not your friend. Law enforcement actually generally cannot help you, and they don't really get much of a say so in what happens in your case and in your charge. They can put maybe sometimes have some input in that, but for the most part they're really not going to help you out when you ultimately are charged and facing court over anything that you are arrested for. And importantly, anything that you say can and will be used against you. And when I talk about this with clients that are sitting in front of me, if they've made statements to law enforcement, I really am really, talk about the fact that it will be used against you. And even if you think that you're saying something that could benefit you or that could help you, I've just seen so many times where something that is said is taken out of context or it's twisted, or you say something with a certain inflection, maybe you say it sarcastically, but sarcastic tones don't come through in transcripts, or they certainly don't come through when law enforcement is on the stand repeating back what you said. So um, just I always advise people that you have a right to remain silent and you should absolutely use it. Don't try to talk your way out of it, or don't think that something that you say or anything that you do is going to prevent you from being arrested or being charged. If you are the suspect and they think that they have enough to arrest you, they're going to. And you saying anything that you like you didn't do the crime or anything like that is not going to prevent them from arresting you. So it's best, always best, to utilize your right to remain silent and not to make statements to law enforcement, because it will be used against you later in court. The next part of that is that you have the right to an attorney. And if you cannot afford an attorney, one will be appointed for you. And what is important to note on that is that even if you're being questioned by law enforcement and that moment, you have one, you have your right to remain silent, but two, you also have the right to have an attorney and you have the right to have one appointed to you if you can't afford it. So what that means is if you say, I want an attorney, and I am not going to speak any further until I talk to an attorney, law enforcement has to stop questioning you. They cannot proceed and cannot keep questioning you until they provide you an attorney. So many times I've talked to people in those situations, and they say, yeah, I was told that I had the right to an attorney, but it was midnight, and it was the weekend, or it was whatever. And I just didn't think there was any way I was going to get an attorney to come down and talk to me right then. And I'll tell you that probably for the most part, unless you have an attorney that that you can call and let them know that you're down there and you're being questioned, that no, an attorney is not going to be appointed to you right then and there while you're being questioned. But what happens is that law enforcement has to stop speaking to you and stop questioning you. And the process is going to continue. You're going to be, booked in through the system and then go to first appearance. And at first appearance, an attorney is going to be appointed to you. And then you can speak to your attorney. And if you decide with your attorney to continue talking to law enforcement, then you can do that with an attorney present. But probably for the most part, your attorney is going to tell you not to continue speaking to law enforcement. So you should absolutely not speak to law enforcement, and you should request to have an attorney appointed so that law enforcement stops speaking to you and stops asking you any questions, and then wait to have that attorney appointed to you during the process of what is going to occur in the system. And also, if you stop speaking to law enforcement, and if you tell them that you want to have your right to remain silent, and if you tell them you want to have an attorney with you before any further questions go on, and to have an attorney appointed to you, they have to stop questioning you. But one important thing to note is that they can't reinitiate a conversation with you. But many times what happens is that, silence is one of our biggest, issues that we have when we're as humans. We don't like silence. So many times law enforcement will still sit there and fill out paperwork or do things because they know generally that the person will start talking again. And if you reinitiate the conversation, if you start talking again and you start talking about the case, they have the right to then to go back and question you. If you reinitiate contact, they can come in and complete the conversation with you. So once you've invoked your right to remain silent or said, I want an attorney, it's important that you stop talking. Sit through the silence, wait it out. It doesn't matter what happens, just stop talking and don't re-engage, don't reinitiate the contact so that law enforcement doesn't have a way to possibly start to continue that conversation with you again. So invoke those rights. And those are the Miranda warnings that we talk about when we're talking about Miranda warnings. So next we're going to talk about, when does Miranda apply? So many times I get asked by clients or by people who are coming in to talk to me, and they say, you know what, law enforcement didn't read me Miranda when they arrested me. Does that matter? Is that gonna, because my case get thrown out? What's gonna happen with that? And so that's one of the things I think that, the cases on, or the television programs and the movies have really kind of conditioned us to think that when we're arrested, that law enforcement has to read us those Miranda warnings, or our arrest or the case is invalid. And that's not true. So when you're arrested, law enforcement does not have to actually read you Miranda warnings at the moment that you're arrested. They can just, put handcuffs on you, arrest you, take you down to the jail, book you in, and put you in booking and let the process go. They don't have to read you Miranda. Miranda applies when law enforcement wants to speak to you about the crime that you're being arrested for or a suspect for. Before they speak to you, then they have to read you Miranda warnings, because remember, Miranda warnings is that you have the right to remain silent, and anything you say can and will be used against you. And you have the right to have an attorney before being questioned by law enforcement. You have the right to have an attorney present. If you can't afford one will be appointed to you. So it's simply, even in the way that they're worded, it is only applies when law enforcement wants to speak to you and wants to ask you questions about the crime that you're being a suspect of or arrested for or charged with. That's when Miranda applies. So, so when those people ask me, Miranda wasn't read to me when I was arrested, can my case get thrown out? My next question is, well, what statements did you make to law enforcement? And if they tell me none, they didn't ask me any questions, then I say, that's great. Then that's not great, but no, nothing's going to happen to your case. They only had to read you Miranda if they were going to ask you questions about the crime. They don't have to read you Miranda just because you're arrested. So if they're going to ask you questions, they have to read you Miranda first and let you know that you have that right to remain silent. So what happens then if they don't read you Miranda warnings? Well, one, if they didn't ask you any questions and you didn't make any statements to them and nothing was said, it was just a straight arrest and they took you and booked you and went through the process, nothing, because they didn't have to read you Miranda. If they asked you questions and they did not read you Miranda warnings before asking you questions on something that you are a suspect and arrested for, then what happens is that we file a motion to suppress your statements. And what that means is that we file a motion to ask the court to say, whatever you said to law enforcement when they didn't read you Miranda and you gave them statements that were incriminating, we ask that that not be allowed to come in as evidence against you at trial in front of the jury. And we make a motion to suppress, and we make the arguments that say it needs to be suppressed and not the statements not be presented to a jury. And the judge, if the judge agrees, then those statements get suppressed or get prevented from coming in as evidence against you in the case. That not reading you Miranda doesn't, even if before they questioned you, doesn't mean necessarily that your case will get thrown out of court. It just simply means that any incriminating statements that you made to law enforcement will not be used against you in your trial. And so the jury won't get to hear those incriminating statements if law enforcement violated Miranda or didn't read you Miranda before questioning you and you made statements to them. Now, whether or not the ultimate outcome is that your case gets dismissed depends upon any other evidence that the state has in their case against you and what goes on. If the only evidence that they have that the crime was done and that you're the one who did it was your statement that you gave, then that may potentially be something that could ultimately have your case dismissed. But if law enforcement has other evidence that they can present, and generally they do, they generally have other evidence that they can present, whether it's direct evidence or circumstantial evidence or any other thing that the state has as evidence in the case against you. If they have enough of other evidence without any statements that you made, then your case doesn't necessarily get dismissed. The state can proceed and try to still prove their case with the other evidence without your statements. So essentially, what happens then if Miranda is violated, law enforcement doesn't read it to you, and you have made statements that incriminate you to law enforcement, then it just simply means that your statements don't get to come into evidence against you before the jury. So that is an overview of Miranda warnings and what they are, when they apply, and then what happens if they are not read to you or properly done by law enforcement. This has been Logically Speaking. I am attorney Siobhan Olivero with Olivero Law, and we are always here to help you and assist you. And if you need anything at all, please feel free to reach out to us. Our number is in the bottom corner that you can call and reach out to us, or find us on our website, or send me a message here on Facebook. Until next time, we will talk to you soon.